when you play under their rules, you can only request. You can't require them to do anything because the judge could deny you all those questions. All the answers could be literally in those answers and the interrogatories or any kind of the answer can be yes and no. They could write yes and no on every single one. Mm-hmm. So when you play this interrogatory game, oh yeah, if you ask me a question on the interrogatories, you're going to get they're going to say if the say the IRS asks me, a question, did you make any money last year? Yes and no. That's the answer. What? Mm-hmm. That's the answer. Yes and no. Did I answer them? Yes, I did. The answer is yes and no. Did I make any money last year? Yes and no. It all depends. What do you consider money? And you didn't ask me that question. You asked me, did I make any money? So literally the answer could be yes and no. See, because if they asked me if I made any money, well, last year I had English pounds, I had Australian sterling, I had Canadian dollars, American. That's people had me silver, gold. What do you believe is money? So yes and no. It all depends. Did I make money? Yes and no. Maybe. Depends. How much? I don't know. So like I said, when you're doing these interrogatories and depositions like that, you got to understand, especially if they have a legal department on their side, the answers you're going to get are going to be ridiculous. Because like I said, when I did that years ago, that's the answers they'd give me. Yes, they'd say yes/no. And the judge would say, no, that is an answer. Yes and no is an answer. Mm-hmm. Because you've got to be more specific. You got to be more specific.
Yeah, or they say no answer request requires a narrative and all these other bogus things that they give. That's another case, though. That's not this case.
You've seen those. So then you've seen those kind of answers.
Mm-hmm, sure. I'm familiar with them.
Right. So you know how ridiculous it gets unless you put in a 9-page document for one single question where you pin them down beyond a shadow of a doubt. It's like arguing with a kid or arguing with a wife. You got to pin them down. You got to ask them, 99 damn questions just to get this stupid answer that you knew the whole time.
Right.
So it makes it almost impossible game to play.
Right.
So like I said, all you should have said is, who do I owe this debt to? And say Cayuga County. Who's going to come before the court from Cayuga County with an exact dollar amount? I mean the exact. And they could lay it out on all paper. They could lay out the documents. They could show every single nickel, dime, and penny where it went. Who is going to come forth and make it known that it's true? Who? Nobody would have. It would have never happened. So I don't know what all this crazy shit that you're going on about. Oh, I know what you're going on about. But I have no idea why you're going down this crazy path when you can just ask the very simple question. I want to pay my damn debts. I'm a very honest man. I just don't believe the numbers are right. Can you show me the numbers?
What you're speaking of is exactly what was entailed for the scheduled deposition.
Okay, what do you mean it's entailed? That's one sentence. What's entailed? Dude, what deposition?
Right, exactly.
That's one sentence.
Your quick and simple Q&A that I've learned off your process.
Dude, it's one question. There is no more. If that question doesn't get answered, dude, there is no second question.
Yeah. I get what you're saying purely, Carl. I'm saying that even though I probably wrote 5 or 6 questions, they were simple and direct, and they were based off state the amount that's owed, state how it's owed, and the ledgering of what was supposed to be paid back. That was it. But the point I was making to you was they didn't show up for deposition. He said that the prosecuting attorney said that he wasn't going to do it until he got an order from the court, and the judge conveniently dismissed the case that was obviously reopened. Conveniently dismissed the case exactly 6 days prior to the scheduled deposition.
Okay, dismiss whose case? His case. The Cayuga case?
The collateral attack with me coming in as plaintiff. And then
what do you mean collateral? Okay, why would you collaterally attack anything? Well, why do we collaterally attack? Dude, what's the problem with asking a simple question? Who's the man from Cayuga County going to come forth and give me the itemized statement of the bill? I have not yet to this date received it, and as soon as I do, I'll pay every damn dime. Why can't you just ask a simple question?
Oh, I did. I mean, I thought you were going to say something else. I did.
Okay, so where is it? Where's the answer? What was their answer?
That's why my original question That's why my original question was, in common law practice.
I didn't use common law, dude. I didn't say common law. I didn't say anything. I don't care if it's administrative, maritime. I don't care if we're two pirates passing in through the night. Who's making a claim I owe a debt? Who's making a claim I owe the debt? I don't care if it's UCC. I guarantee anywhere in any of these ridiculous court scenarios that you're putting on in your head and your brain, and let's say commercial, I guarantee as soon as somebody walks into the courtroom and says, who's the man on the prosecuting side who's going to come forth and just give me the itemized statement of the debt so I could pay it and so we could go on with our lives.
Right. Who's going to
forth and hand it to me? So what did they hand you? What did they hand you?
Nothing. I have been
okay,
on the
well, then you can't do anything. Dude, then you just say to the court, I can't do anything until I get the bill. How can I pay a debt? How can I answer to something that I know I'm charged with? I don't know what the charges are. What's the charges? How could you answer to doing something, a debt or a wrong, if you don't know what the exact charges are? You want the exact charges so you can answer them definitively. You don't want to kind of in a ballpark. I don't know, maybe about $1 million you owe. It's probably a little less under than $1 million. Oh, can you be a little more? No, not can you be a little bit. You better be a little more exact because if you draw 1 ounce of flesh, 1 drop of blood, 1 hair of breath more than is due to you, you know it's instant death for you, right? You can't claim more than what's due. You do know that, right? So who's going to stand on this witness stand right now and swear that I owe the debt and it's exact? And how much do I exactly owe? And how did you come to that number? Show me. Just show me how you got it. That's all. How tough is that?
It's not.
Collateral attack. What's all this collateral attack nonsense?
Well, I was explaining to you what I had done. That's why I was explaining the process. And then when you look up void judgments or whatever that they actually honored, which I was explaining in the beginning, that's why I went through the whole explanation of it. So now, going back to the original question, is the process of scheduling an evidentiary hearing, was that something that you identify with?
Dude, as soon as I walk in and I say that one sentence, I flipped it into common law.
Remember how
Dude, I could be on planet Vulcan, and that's their common law, too.
Listen, I appreciate all the examples.
Dude, you're flipping into common law just by asking a simple question. What Vulcan on this planet is going to come forth and say, I, an Earthling, owe him a debt? Just bring it forth and I'll compensate. Dude, it's that simple.
I get you, Carl, 100%. I'm enjoying the call and the dialogue. I'm just asking a question as to, like, you mentioned several.
You just put that one simple question before the court and be done. Until that question is answered, you can't go to question 2. There is no question 2.
I get that. Listen, on several calls, you've announced and you've explained how you can hold court at any time. You can hold it Christmas Day, 1 o'clock in the morning, and they have to come per your summons and, press the record, right?
You better be a damn good reason why you're being an asshole to them, though, right? You got to be courteous.
Okay, I get that, right. Right. So my question is, that's the reason that I'm invoking the question on the call. So my question is, when you do that, when you want to hold court, whenever the hell you please to hold court, and whoever the hell you want to haul in the court, if I want to haul in that prosecutor and say, listen, it's been 90 days since I've been asking, what does the amount due? Press the record and state what it is so I can do it, and you better not be not 1 iota, not 1 centavo off with the so-called demand for the payment.
You don't talk to anybody like that. You don't say 1 centavo. Dude, you got a lot of balls to think that they'd be dishonorable and they don't know the rules. Of course they know the damn rules. And you don't threaten nobody. No, dude, you don't threaten nobody.
What was the threat?
No, dude, you said you better be accurate to the penny, to the centavo. No, dude, you don't have to explain to them the rules. They know the rules. The last thing they want to hear is somebody arrogant jumping in their honorable faces. They know the rules. You want an itemized statement of the bill, and you'd like the bill immediately so you can settle the debt. That's all.
All right.
Simple. You're an honorable man. You want to settle all debts. You want to settle all debts. That's all you're basically saying. I, blah, 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 whatever the hell your name is, being an honorable man, want to settle all debts. I am just looking for the itemized statement of the bill, and I'd like to have the bill sent to me forthwith so I can settle the debt. So there's no controversy. If I got this bill before they filed the summons for me to appear, I could have settled this in a private. For some reason, they don't know how to, for some reason they didn't do it.
Mm-hmm.
All they have to do is tender me the bill. And then they toss you this ridiculous bill. They say, okay, can you give me an itemized statement of the bill? And it's like, okay. And then they'll give you the itemized statement and say, okay, just how much did Cuyahoga County have to put out? How much of this was federal grant money was reimbursed? How much did they get from the state from reimbursement? Was this the layout of the county, and the county never got compensated from the feds or from the state at any level whatsoever? This is 100% pure county taxpayers' money. Is that what I'm reading here?
Mhm. That's good.
Yeah, that's what you want to ask them. Right. That's the simple little questions you want to ask them. The first thing you want to ask them is where's the billing? Where's the itemized bill?
Yeah. Well, what I mentioned to you was for humor, Carl. I wouldn't have actually said what I said to you in court. I mean, I got sent.
Yeah, I know what you're saying, man, but that's what I'm saying. They know the rules.
Right. I never said that they didn't. You know, I'm just saying that the next step that I want to do, since everything is on the table, as it is, and right now it seems like I'm, holding the authority for the next situation to be presented. So, and again, that's what I wanted to say, or my suggestion and my question was, when you gave the examples as to when you want to hold court at any time, you go down to the clerk of courts and say, I want to hold an evidentiary hearing on this day, or you can do it at any time. You can do the notice and demand for a hearing like right off the rip, right off the cusp.
No,
is that right or wrong?
No, you can't, because it's their court. It's not your court, it's their court. Did you open a claim against them?
That's the key right there.
You didn't open a claim against them, did you?
Yeah, that's we.
No, you didn't. You said he did a collateral. You said he did some sort of collateral nonsense.
Right, and the collateral attack is.
That's not the same as making your own claim.
I mean, I already know how you feel about Supreme Court rulings, but have you not read on anything on void judgment and a collateral attacks?
Of course not. That's ridiculous. It's ridiculous to even think about such a nonsense, because I'm not part of the legal society. It's ridiculous. What collateral attack? I know exactly what you're talking about. I know it's, dude. I know, man. I read so many void judgments. It's not even funny. I know all about Rule 60A through G. I know every 60A, B, C, D. So what? I don't care about void judgments.
Well, actually, I didn't.
Void judgments don't exist in common law.
Well, yeah, I know that. So,
okay,
but
one time else we care less. Look, dude. Like I said, that was great about me bringing my sister down to Alabama. Because like I said, we went to like the biggest law firm we could find, and it was like Bernstein, Auschwitz, and Cohan. It was a big Jewish law firm. And like my sister, and they told us, they said, look, if we help your brother and we win his case, which we will. They said, do you realize that every single case that we've ever had, every judgment we've had that is in our favor will all be deemed void? Do you realize they'll all be turned over? Because we went against the state. Do you understand what they're going to do to our law firm and all our clients that came before you and your brother? Do you understand they have the power and authority to turn over every single judgment within their legal world, in their legal society?
Yes, you've explained that earlier on previous calls.
Okay, I explained it millions of times. So whatever you want to believe is a void judgment, any kind of judgment to me is a joke. Within their legal society, they could do it any way they want, and there's not a damn thing you could do about it. And you take it all the way to the Supreme Court, and they're going to say, well, you know what, the lower court made a ruling, and in our opinion, the lower court made an error in their ruling. Take it back to the lower court. And all the lower court is going to do is like, I don't care you went to the United States Supreme Court. I don't care you fought me 25 fucking years. I don't care. This is the court of original jurisdiction. I know what I witnessed, and my judgment stands true. So good thing you wasted all your time with appeals and Supreme Courts and all this other crap and nonsense. Lovely, you wasted all this time, because what did the Supreme Court say to do? Take it back to the court of original jurisdiction and let them try the case again. They're going to rule the same damn way they ruled against you 25 years ago, dude. You're wasting your time. You know, trying to remember the man's name, man, in Alabama. The Alabama Supreme Court clerk down there who was there for like 23, 25 years, whatever he was doing it. He says, dude, it's a total joke. He says, the appeal Supreme Court cases, that you're involved with are a total joke.
Yeah, it's a money-making system.
He says it's a joke. It's just a time to waste your time and waste your money.
Yeah,
he says,
it's a money-making system.
Right, and the Supreme Courts in these states, they get elected. You could go run and be a Supreme Court judge tomorrow. It doesn't mean you're an attorney. It doesn't mean you're any damn thing. It means your name was Abraham Lincoln and you had a D next to your name, so everybody in your neighborhood voted for the party line, voted letter D, and your name's Abraham Lincoln or Martin Luther King. You're going to win. You're going to be the next Supreme Court judge in Ohio.
Mm-hmm.
Doesn't mean that anybody judged your merits. It's like, oh, wow, look who's running for the Supreme Court judge, Martin Luther King. And you're going to win. Oh, look who's running for, governor of Ohio, Abraham Lincoln. Let's vote for him. It's retarded. People just want to vote for the name of the party line. Dude, the judges don't mean that they know a damn thing about law. So, like I said, all this collateral attack nonsense you're talking about, to me, it's ridiculous. All you want to do is go in there and a man say, look, I want to pay my debt to society. Who do I owe?
Right.
How much?
Well, I wasn't dwelling on the success around the collateral attack. I wasn't trying to explain the collateral attack and or avoid judgment for that matter. My question goes back to the same thing I've been asking. At this point in the game, how do I press the record or go forward or push forward or put the pressure on, whichever way you want to say it, to bring that statement to the forefront? Everything you just said. You never heard challenge jurisdiction. You never did what?
You never heard you could challenge jurisdiction at any time. You never heard that.
Of course I did. That was portion of my voice. Remember I said I never took the DNA.
There you go, dude. You're challenging jurisdiction then by asking, where's the damn bill? What controls me? What's bringing me here? There must be a bill. There must be an outstanding debt, a harm, or an injury. There must be something that's compelling the other side to present me to the court every 5 seconds. What is the moving instrument? What's going on here?
Okay.
How did this jurisdiction get us? How did they establish jurisdiction over me? Where's the debt note? Where's the IOU? Where is it?
Mhm.
Yeah.
Okay.
Challenge jurisdiction.
All right. Well, that was already done in that thing you keep slapping me around with, that void judgment.
Okay. And how did they challenge? And how did you challenge jurisdiction?
Because the proper parties were never before the court. How in the hell did you hold court without the proper?
How about the debt? How about the instrument that was moving the court wasn't there? How about the debt instrument wasn't there? How about how the hell would I know? But how the hell would I know whether that the debt instrument wasn't there before the court if I was never in court? If they fail from the rip or proof of service of process or sufficiency of process, or whichever way we want to identify it, if I never got properly served, then how can I come to court? How the hell did they hold court? Wait, hold on, give me a second. How the hell did they hold court without me knowing there was court to be held and then make a ruling absent the parties for the court? That's one of the. Listen, I don't read over. Dude, just say, you know what? You know what? Say the other side. They're absolutely right about everything. I couldn't care less. They did everything 100% kosher. I couldn't care less. Now, who's the man who's claiming I owe the debt? Where's the bill? Okay, right. So again, am I like inhaling a different kind of air? I hear you, Carl. I'm not dumb. I'm saying the next stage in the game to present that fact before any judge, any man in a skirt, whatever we want to call them, anybody that's acting like they're, king of the hill. How do I get them to come forward in the absenteeism of the prosecutor who's not going to show up with shit? That's my question. Okay, dude, it's okay. If you want to play the legal game, it's a motion to show cause. No, I don't want to play it. You haven't. Dude, every single thing you said this whole time has been legalese. You want to play the legalese game? I'm telling you the legalese way to do it. Do a motion to show cause. Okay. I mean, I'm not going to do that. I mean, I hear what you're saying. You do know that. You do know how to do a motion to show cause, right? Of course I know a motion to show cause here. Of course you do, because you're so enamored in this legal shit, it's not even funny. Of course you do. So go do your motion to show cause and say there is no case, no cause, because there has been nobody has ever come forth and brought forth the debt and informed the court what the debt is. How can I answer the court? How could a judgment be passed? How could anything be ruled upon until a debt note is coming to the court, until the itemized statement of the debt has been presented to the court? I don't see it in the case file anywhere. Just do a motion to show cause. You want to play legalese? Play freaking legalese. I ain't playing effing legalese, but if I was going to do it, that's the way I'd do it. Well, actually, I'm glad that you explained that for, the educational purposes for everybody that's listening on the call, because that's not my intent. I've done motion to show cause hearings. But what was the motion to show cause? The motion to show cause was what? It's garbage, because your motion can be denied for one, as you've mentioned and explained several times over. It's not going to be denied. Dude, they're going to have a hearing for a motion to show cause.
Well, I'm talking about
dude, I've never seen them not have a hearing over that matter to show cause.
Yeah, well, the same thing for default. They branch it. They dance around
default. You just have to have
a
motion. Just put a motion to show cause.
Okay.
Make it very simple. One sentence. At no time has the itemized statement has the bill been presented to the court of a debt that is due. Not at any time. And let them say whether that's true or not. And then take it from there. Has the itemized statement, has the bill ever been presented to the court? Have they ever presented me the court? Have they ever presented to me or the court the bill? How much money do they say you owe?
I don't mean to laugh, Carl. I apologize. They never gave
how
it
much
to me.
Then how could you do that if they never gave it to you? Why the hell are you doing all this crap?
All they did was
if you don't know what your charges are, how could you answer? All you're doing is a motion to show cause. What is the charges, man? What am I charged with?
They have you know how child support goes. What they have is an expectation of a reliable so-called debt-related issue that they're counting on every month or twice a month, however somebody is paid, and they garnish it there too for the life of the child. And even I got friends that's got these so-called exorbitant fees after the child is long emancipated. You know how it is. In fact,
because everybody else smokes dope, does crack, drinks beer, it doesn't mean I have to play the stilly game. Don't tell me it's an expectation of how this is going. No, dude. Good law is expressed, not implied. Don't just say, well, you know how they do it. Everybody does it. Look, you tell me how much I damn well owe. I'm not like everybody else. I'm not like some dumb schmucks here who'll just let some silly lady with glasses who's got a big pile of paper in front of her tell me that I owe this much money to the state. Why? Oh, because it's expected that everybody pays and everybody knows it's true. Oh, good. The only problem was me. I want an itemized statement of the bill. Just like when you go back and listen to my show. No, dude, you go back and listen to my show a long effing time ago. One of the first things I said on that show was when the Alabama judge said to me, hey, we had your kid now in captivity for six years. And not at one time have you paid any child support. You're $100 and something thousand dollars behind. I said, lady, put it in a form of an order and sign, and I'll pay every damn dime you say I owe. She said, well, I don't say you owe anything. Well, then who says I owe something? She said, the state of Alabama. I said, well, where's Mr. and Mrs. Alabama? He was just sitting right over there in that chair. I said, are you Mr. and Mrs. Alabama? It's like, no, I'm the prosecuting attorney for the state of, okay, Alabama says I owe a debt? Yeah, well, you get on to put it in writing, and you tell them to sign in a form of an order that I got to pay the state of Alabama. I'll pay them every damn dime I owe. And the judge said, well, you got to just pay your child support, you're going to go to jail. I said, are you communicating threats? Is this extortion? I already told you I'll pay every damn dime I owe. Put it in a form of an order and sign it, and I'll pay it. She said, well, you just better. Oh, what, ma'am? Are you communicating a threat? Are you ordering me, ma'am? Well, no. Well, you just better pay what, ma'am? Are you talking to me or is the state talking to me now? Who's talking to me? So don't tell me I know how everybody else gets treated in child support court because you're a bunch of schmucks.
No, the point I was making was the mentality of the government officials and what they expect.
I don't give a damn, dude, because when you talk to the government officials like I talk to them, they shut the hell up. Because when the lady who stood behind me, when she owed it was $200 or $400, so she was like 2 or 3 months behind. She said when they called her up, they said, why haven't you paid child support? Well, and the lady said, well, exactly what he just said. And they said, give her a pair of silver bracelets and take her out of here. Because they knew me, I wasn't fucking around. They knew me. I owe hundreds of thousands? Yeah, this lady owes $200-300. Guess what? She's going to jail. Why? Because she said, whatever he just said. No, because they know if they fuck with me, man, they just committed extortion. They know they just communicated threats. I told them I will pay every damn dime. I'm just waiting for the effing bill.
And Carl, let me say this, and the reason why that is true too is because they know when you start talking, you're speaking, and they know where your language is coming from. You're speaking as a man, and I think that's the difference that they know. They know when a man is talking, so they're gonna back off and everything else. But when you're talking legalese and you're talking their language, yeah, they're gonna definitely treat you like. And that I think Cleveland, that is what the conversation is going when you go in with legalese and everything else. Yeah. you're right in that ballpark. You're right in that jurisdiction, and then you're trying to mix the two, and you can't mix the two. And you're thinking you're not, but you are mixing the two when you're using your legalese and trying to use common law also. So that's why you got to be real careful about the legalese and everything, as because you will get caught up in it, and that's what.
Could have I went into that child support hearing that they summoned me to appear? Could have I done a collateral attack? Could have I used all these lawyers? Of course I could have used all this crap, but why? I just said, look, I'm a man and I'm here to pay any damn debt to any man who's come forth to say it's true. Just put it in a form of an order, hand me the effing bill, and sign the damn thing. They won't do it. Not if you know how to stand in court and act like a man. They know when you're bullshit, they know when you're bluffing, they know when you're faking, and they know when you're just putting on an act, and then they know when you're deadly serious.
Yep.
Yeah, they could read right through the bullshit. They're just like any other man or woman on planet Earth. They could see a bullshitter from a mile away.